and it was composed by a person named Andrew Alsey, who sold that composition to a group called Confetti Records. Now, Confetti was a small label specializing in something called UK garage or speed garage music. You probably know more about this than I do. But what Confetti did was it hired a group called the Anthill Mob to record it. And this was what's known as a concept group in the music business. So it had no permanent members. It was just session musicians who gathered together, formed this group, and made the recording. The song turned out to be successful and actually rose to the #1 spot on the UK Garage Top 10 list. When that happened, it was noticed by the Heartless Crew, a UK garage group, who wanted to record the song in their own cover, their own version, and they did so in the format and under the title Crisp Biscuit. So it's the name of both the album and the technique, the sort of layering of different sounds that gives it that particular feel. The case actually is a contract case because in the process of trying to obtain the license for the song, the Heartless Crew got into a number of mishaps. But we'll leave that aside given the brevity of the time, and I'll just talk about how moral rights under the Copyright Designs and Patents Act of 1988 arose. So basically, moral rights became an issue because Andrew Alsey, the original composer, said that the remixed version of the song included references to drugs and violence, to which he objected. So if we look at the relevant section, Section 80 of the CDPA, the Protection of the Integrity Right, the legal question became very interesting. Whether this section could be broadened beyond a reputation interest. What do I mean by that? Well, the language says the treatment of a work is derogatory if it amounts to distortion or mutilation of the work or is otherwise prejudicial to the honor or reputation of the author or director. And what the plaintiff's lawyer tried to do was to split that last clause off from the rest of the provision. So a distortion might be a violation of the right of integrity, a mutilation might be such a violation, or some other act that's prejudicial to the honor of the author might be a violation of the right of integrity. So could this mean that any mutilation or distortion violated your right of integrity, or did you have to prove damage to reputation became the key question? And of course, if that question had been answered in the affirmative, it would have taken the British moral rights scheme, very conservative and carefully drafted as it was, and transformed it into a French-style open-ended protection for moral rights. So the judge in the case, not surprisingly, did not buy that argument. He said that it just had to do with the way the section was written. It was the compressed drafting style of the UK legislature that was behind the construction of that phrase. Nevertheless, the court had a great deal of difficulty even in dealing with the pared down version of the integrity right contained in the Act, because it couldn't quite assess the issue of damage to reputation on which the whole thing turned. The reason for that being that it was hard to assess what the song actually said. In particular, the use of special words and sounds by the rapper was noted by Justice Lewinson, who said, "This complaint led to the surreal experience of 3 gentlemen in horsehair wigs examining the meaning of such phrases as mish mish man and shizzle my nizzle." So the court said the problem in understanding the words militated against a finding of an integrity violation. Now, could they have called in expert evidence? There too, the court felt limited because it felt that only drug dealers would know what was needed to know in this case. And Justice Lewison comments, the occasions on which a drug dealer might be called to give evidence in the Chancery Division are likely to be rare. I think they could have called police witnesses, but anyway, this was his view. And they also attempted to use a dictionary, an online urban dictionary from the internet, to help them to figure out what those words actually meant. And there was another factor that came into play too, a more practical one, which was that the Anthill Mob in their original recording appeared in gangster-style outfits. And so the question became, why did Alsey not object to that particular manifestation of violence in the preparation of the composition? Now, given the way in which the plaintiff's lawyer had framed the claim, no evidence was offered on the reputation issue. The plaintiff's lawyer was hoping that he or she wouldn't have to. And so the judges were stuck as far as reputation went. What was Alcy's reputation? How did or could the remix affect it? They had no answers to these questions. And so, of course, the case failed. Perhaps it's a bit of an opportunity missed because it did have this interesting undercurrent of a chance for artists to take some moral or social responsibility for something that they create. And I don't know how significant the costume issue really was. I don't know how significant the issue of finding expert testimony on the drug side of things was either. But I'll leave you to develop your own opinions about that. Canada is an interesting case because we, of course, have this historic mixture of French and English traditions, which also applies to some extent in the area of copyright. We do have continental and British traditions of law. And sure enough, Canada was the very first common law country to enact moral rights of the author. We did that in 1931, just 3 years after they were first enacted in the Berne Convention. So we were, as always, I think, like to think, good international citizens in this regard. But I'm afraid the good news on Canadian implementation of moral rights stops there, because in the entire history of these provisions, as I mentioned earlier, there has really only been one clear success in terms of litigation. So there's great practical ambivalence about moral rights, including the fact that standard form blanket waivers of those rights are the norm in authors and artists contracts in Canada. The successful case relates to the picture on the screen. That's actually a sculpture called Flight Stop by a gentleman called Michael Snow, and it decorates the Toronto Eaton Centre, probably Canada's most celebrated shopping centre. And one Christmas time, the owners and administrators of the shopping center got into the festive spirit and decided that they would decorate this sculpture with some festive ribbons, and other cheerful sorts of seasonal decorations. And the sculptor was quite upset by this, felt that it destroyed the artistic integrity of his creation, and he sued. And in that case, in which he was successful, he called experts from the art community to talk about how indeed his artistic reputation was likely to be damaged by the association with the decorated version of his work. The judge was persuaded, and the order, of course, was to remove the ribbons forthwith. Now, though, we're seeing a very interesting legal movement in Canada, which is more interest in the area of moral rights, more litigation, reaching now up to the Supreme Court level, and a problematic issue, a split at the Supreme Court between English and French judges. And the legal issue on which all of this is turning seems quite arcane at first. It has to do with the relationship between economic and moral rights. And basically the question is, are they two sides of the same coin, or are they two distinct families of rights on their own? And there are actually two names for these schools of theory, one being the monist approach, which is two sides of the same coin, the other being dualist, which is the split between the two branches. And again, it seems like a fine point of theory, but it has very important practical implications. So in France, the way that we get perpetual protection for moral rights is through a dualist system, because economic copyright has to be time limited, but the moral rights are potentially free form, and so they're allowed to persist forever within the French copyright law. So duration is affected by that theoretical point. Now, legal systems may not always be entirely clear about the doctrinal basis of their protection for moral rights. They might have a hybrid or mixed system. That's somewhat the case in both India and Russia, as hopefully we will see. But in Canada, what we really have is confusion. And the confusion has turned on this particular issue. Do we have a monist or a dualist approach in our legislation? Or, alternatively, but we haven't quite got there yet, eventually, do we want to forge a mixed approach? Now, we do have a monist system in the sense that duration of moral rights is limited, so it lasts as long as copyright and no longer. But in a 2002 Supreme Court case called Théberge versus Galerie d'Art du Petit Champlain, the Supreme Court seemed to reject this monist theory. When it did so, it took the existing dualist theory and turned it completely topsy-turvy. So, as I've already suggested, the traditional meaning of dualism is more extensive protection for moral rights than for economic rights, because it's a natural rights theory. But in Canada, when we espouse a dualist theory, we mean that we give less protection to moral rights than to economic rights. And then, to confuse matters further, in 2003, the Supreme Court had another ruling, and it made an off-the-cuff remark that actually Canada is governed by monist theory. So, what happened in Theberge that gave rise to this debate? The case had to do with reproduction of an artwork. And what essentially happened was Claude Theberge is an artist, a painter, who authorized the making of a number of souvenir items associated with his work, so postcards and other works of that kind that would reproduce his original images for the purpose of souvenir sales. And what eventually happened was that another company came along and decided to make canvas-backed reproductions of his work. What they did was to take a postcard, lift the ink from the postcard, and superimpose that image upon a canvas. So note that in this process, there's only one copy of the work at any given point in time. Okay, the postcard exists at the beginning, the canvas is blank. At the end, the canvas bears the image, the postcard is blank. Believe it or not, that is actually the key factual issue on which the decision turns. So the artist actually gave evidence that he wasn't especially concerned about the commercial consequences of these new canvas-backed reproductions. What he was worried about was his reputation. And he felt, presumably, that people would be confused when they saw those canvas-backed works and think possibly that they were original works by him. When the Supreme Court considered the case, it came back and said, the majority, I should say, said that no reproduction had occurred. The reason being that there was one copy at the beginning, one copy at the end, and that multiplication of copies is really what defines reproduction. One of our outstanding judges actually gave that judgment, Justice Binney of the Supreme Court of Canada. What he said was that Theberge was doing something a little bit underhanded. He was trying to make a moral rights claim about his reputation while framing it as an economic rights complaint. And Justice Binney said, well, you can't do that because there's a different standard of proof that applies to moral rights claims. You know, when it comes to copyright, any unauthorized act by definition is a violation of copyright. But as we've just seen in those few examples, when it comes to moral rights, usually you have to prove that there has been some damage to your reputation before you have a right to complain. And so Justice Binney said we have to be very careful. We have to protect that